Courtmaster, Washoe County Second Judicial District Court, June Evans, Juvenile Justice Facility.
All right.
Good morning. We are Unit 5 from Reno High School. My name is Roberta.
My name is Kat Lynch.
My name is Jacob Hobart.
My name is Ashley Dreer.
My name is Gigi Atem, and our unit coach is Mr. Scott Daniel, and our teacher is Mr. Richard Clark.
Perfect. Will you select the question 3?
The question 3, what fundamental American values are embodied in the Fourth Amendment? Why have Fourth Amendment issues been a consistent concern to colonial times until today? And how and why does modern technology raise new issues and concerns about the Fourth Amendment?
Confucius, innovator of Chinese politics and law, wrote, "Better a diamond with a flaw than a pebble without it." The Fourth Amendment shines as a constitutional diamond by promoting the fundamental values of the American people and protecting them from the flaw of government abuse.
The Fourth Amendment embodies essential values that define the American people, including the value of individuality through the freedom of conscience and thought, the value of privacy, and the value of the rule of law. Justice Lewis Brandeis's dissent in the 1928 case Olmstead v. United States stated that the Fourth Amendment sought to protect Americans and their beliefs, their thoughts, their emotions, and their sensations, all elements that can contribute to a citizen's freedom of thought and conscience. The very language of the Fourth Amendment shows the embodiment of privacy, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. This is shown in the 2009 case Safford Unified School District v. Reading, which found that it was unlawful for a school to strip search a student and invade her privacy without consent. Additionally, finally, the very language represents the specific wording of the amendment shall not be violated and no warrant shall issue but upon probable cause, which plays directly into the concept of limited government and rule of law by promoting negative rights or rights against government intrusion, which embodies the values of republicanism.
Issues of government abuse have been a persistent debate from colonial times to modern day because the government has continued to infringe upon our enumerated rights the Fourth Amendment grants citizens. Beginning with the Molasses Act of 1733, colonies were outraged over the issuance of writs of assistance, which allowed British tax collectors and law enforcement to search and seize smuggled goods, like molasses, but contained no specifications about why, where, or how they would perform these searches. In Paxton's case, James Otis defended 63 enraged merchants in 1761 when he gave a persuasive speech at the State House arguing that writs of assistance appeared to him the worst instrument of arbitrary power.
In the 1765 case, Entick v. Carrington, Lord Camden ruled in favor of a disgruntled citizen, John Entick, whose home was invaded by English loyalists to the king. He stated, "By the laws of England, every invasion of private property, be it ever so minute, is a trespass." However, these problems of government abuse were not reserved for colonial times. The 1925 case, Dummer of the United States, and the more recent 2014 case, Riley v. California, restricted government action and more clearly defined the rights and values enumerated within the Fourth Amendment. Thus, it is clear that issues surrounding government abuse and our right to privacy have been a persistent concern dating all the way back to the 1700s.
As technology increases the government's power to search without trespassing, the literal and metaphorical space considered to be private is placed in flux, and the court is forced to readapt the basic principles of an 18th century rule to 21st century rights. Jurisprudence of the Fourth Amendment in the new millennium has ventured even deeper into objective and subjective expectations of privacy than Katz v. United States in its phone booth in 1968. Thomas Jefferson wrote, "In matters of style, swim with the current. In matters of principle, stand like a rock." While the interpretations of the Fourth Amendment must be adaptable, the principles and ideas behind the amendment are what must remain the same and be protected by these adaptations.
In the 2001 case, Kylo v. United States, the police collected evidence by using a thermal imaging device from outside the home. In the 2012 case, Jones v. United States, the police placed a GPS tracking system on Antoine Jones's car. Despite the fact that there was no physical trespass in either of these cases, the court ruled these searches with technology as a violation of the Fourth Amendment, as it did not pass either the subjective or objective test of reasonable expectation of privacy. The idea of what constitutes a search has had
case law and judicial review, you have to have an amendment.
However, we can see through cases like the NSA and the Patriot Act and then surveilling the citizens' emails and other things like that, what we've come to see is that we don't actually need an amendment to change this. It can be changed through decisions in the Supreme Court. We can clearly see that documents, as defined by the Fourth Amendment, has expanded it to include emails, phone calls, wiretaps, and things like that.
Additional question, why has it proven more difficult to define what contributes as an unreasonable search? Or has it become more difficult to define what constitutes an unreasonable search or an unreasonable seizure?
I think it has become more difficult because we see that with technology, the things you're sending, you may not have the same reasonable expectation of privacy that you would have, say, in your home.
However, at the same time, it's almost become easier to define exactly what a reasonable search is because of their more concrete definition of probable cause. And the way the definition of probable cause within the Fourth Amendment has been changed from colonial times and more defined through cases like Illinois v. Gaunt, which talked about totality of circumstances. So it's become more easier because we recognize the nuance in defining what things actually constitute reasonable searches.
I would disagree with Carla and say that it's actually become much harder. With terrorist attacks like the Paris terrorist attacks or the shootings in San Bernardino, people are saying that government surveillance or government search and seizure of people's homes could actually prevent some of these attacks. So now we're getting down to the common good versus individual rights, and it's truly muddling this distinction.
I would agree with Jake in saying that it is harder in the fact that probable cause and reasonable suspicion, they're not clearly defined, where probable cause is it's more likely than not, where reasonable suspicion, you just have less evidence than probable cause.
Picking up on probable cause, can you tell me exactly what probable cause is, when it is required, and why?
The case Breingar v. U.S. gives us the most concrete case law definition of what exactly probable cause is. And it's rather vague because it really only says that probable cause is enough knowledge contained or that's accessible by the person such that they would have a reasonable expectation that a crime has taken place. So probable cause is very hard to define in the fact that it's very circumstantial.
Probable cause is where you have a thought, and it is not where you have actual evidence of what it is. So probable cause cannot get you a search warrant, but if you have a reasonable suspicion, or no, probable cause can get you a warrant. Reasonable suspicion cannot get you a warrant. So probable cause is where you do have evidence, and reasonable suspicion is where you do not have evidence.
Although in probable cause you may not have evidence, it is, like I said in the last question, that it is more likely than not, even though you don't have some evidence, that you have some suspicion that it's more likely than not that this is happening.
And why, when is it required and why?
It's required to get a warrant because, like we talked about in our testimony, the king used to issue writs of assistance, which just said that they could search anything for really anything. And these warrants specify a time, a place to be searched, which really limits where the police can go and really enhance our individual rights.
However, there are exceptions to the warrant requirements, such as if a person consents to a search, if there's time of special need, or if it comes into a time of like border searches and like TSA, a good example of that.
One of our questions, we talked about modern technology and raises new concerns about the Fourth Amendment. So thinking about that for a second, we have rights versus freedoms versus safety. How much safety or freedoms should we give up, or should we give up to enforce these rights?
Benjamin Franklin once said, "He who gives up essential freedom for a little bit of safety deserves neither freedom or safety." And we can see this in mass surveillance, and we can see whether
something that we should be concerned about. Simply because I'm not worried what the government has to hear on my private phone calls or private emails, because I'm not doing anything wrong. However, they're looking for terrorists and they're looking to prevent breaches of border security. They're looking to prevent terrorism. So in that case, I do think that the abridgment of individual rights really is beneficial.
Can you
Agreed.
follow up on that really quick, and I
Sorry.
apologize. Didn't we say initially when we talked about, the early evolution of rights and that the British did exactly what you proposed about just searching and just walking into our homes?
Well, the most important thing to recognize really quickly on this issue is the fact that they still do have to get warrants to do those searches. That goes through the private courts, which are still a court that issues a warrant. And additionally, what it comes down to is this issue is very complex, and it's hard to strike that good balance between what the common good means versus what individual rights that we have to protect. And as you can see through the many different debates that have gone on, the changes they've made, the Freedom Act and things like that, that this debate is still ongoing, and we really haven't found a really good answer yet to it.
But isn't it true that in the FISA courts, that the warrant is actually obtained after the intrusion? That's an unfair question. But
Are we out of time?
Oh, fine.
All right, so just some brief feedback for you guys. I think it's always a good sign when judges lose track of time, because it means we want to hear more from you. So what else can I say? I think that was so great. You guys really almost kind of shocked me with the amount of Supreme Court cases that you loaded up on us, which personally I love to see, and is just great. So I would just say keep doing what you're doing.
I would have nothing but praise. You're very well prepared. You're very supportive of each other. You have lots of eye contact, which provides me with a level of confidence that you understand quite deeply what you're professing. I understand. I like the disagreements that arose, because those disagreements are fundamental to arriving at an appropriate conclusion. And they're just fundamental. Great job.
I agree. I think you played well off each other. I think looking at the judges, it's obvious that they were very prepared. I think obviously, as you self-reflect on today, you're going to want to go back and look at the probable cause doctrine and know that definition, because it's important that when you're debating, you understand and you own and know the terms that you're throwing out, whether it's an exclusionary clause or reasonable suspicion or probable cause, that you know exactly what those terms of art mean, because they are the underlying foundation of your arguments. I also think that it's important that you own the cases that you're citing. You're doing a very good job of citing the cases. Now, to take it to the next level, own those cases. If you are going to argue that because we're not criminals, we're going to go ahead and give up our liberty interests for security, you need to know the cases that are going to stand behind that position, because that is a very, very controversial position to take. And you need to know that if you're going to take that position, you can back it up with the case law to support you. Because obviously this has been the tension since colonial times between liberty and security. It's not new. But if you're going to argue against one of your teammates in the positions of Benjamin Franklin or the Anti-Federalists, be able to articulate your position against those people. Good job.